Hello everybody. So today I wanted to do a video on lawsuits, and I'm going to explain to you how lawyers who you hire for civil litigation can charge you fees on three different formats. And those three formats include contingency fee basis, an hourly rate, or a flat rate. Now, these are three different ways lawyers can charge you fees, and you have to understand these in order to understand how and whether or not you should continue with your lawsuit. Contingency fee basis lawsuits are those mostly involving motor vehicle accidents. That's when a lawyer sues an insurance company where they're guaranteed to return money because they know insurance company has a lot of money. So in those kind of cases, a lawyer will take your case if you are the injured party and you are not at fault, meaning somebody hit your car, you broke a leg, you broke an arm, you were injured, you couldn't go to work. So the lawyer knows he's guaranteed liability on the other side that hit you, and he's also guaranteed a return of money because he knows the insurance companies have a lot of money, and therefore the lawyer is at no risk proceeding with a claim where they can sue the insurance company, and because you were the one who was injured and you were not at fault, you're going to get money. And in those cases, the lawyers will charge you a percentage. They may either charge you 20 all the way up to 30%. And so if you were to collect $100,000, the lawyer would charge you up to 25 to 30% depending upon the percentage. Also, they will charge you disbursements, and they may charge you medical costs and so on. So you have to be very careful on those contingency fee basis. I've seen many cases where clients have come in and said, look, lawyer said I'm going to get charged 25%. I ended up getting $100,000, but the lawyer didn't just take $25,000, he ended up taking $55,000 because all the disbursements and costs associated with these issues. So clients become very disgruntled and unhappy by the fact that they had an agreement and they seem to think that the lawyer has violated it. That's not really the case in most instances. It's just that the client never understood all the fees that the lawyers would be charging. Now, those are contingency fee basis cases where a lawyer says, I'm going to collect money and then take my share from what you win. In those cases too, you have to be very careful, because if you start frivolous lawsuits in a motor vehicle accidents, and there's a lot of them out there, people get into small accidents and they go to a lawyer and the lawyer says, you know what, we're going to sue for $1 million. Well, there's no chance of collecting $1 million on a personal injury where you've broken an arm or a leg and that's the extent of your damage. But if you're losing a livelihood and it goes on to a debilitating injury or you're paralyzed, those are different kind of cases. But throughout the years, I've seen personal injury lawyers just sue. Every single lawsuit involves $1 million claim, and that's not what people are going to get. So you have to be very careful when you make a claim in that large amount that you can back that up with damages, because if you don't, the consequence is the other side can make you offers to settle at smaller amounts, and if you don't accept them, that's when the problem comes, because your lawyer may not be charging you fees unless you win, but the defense, that's the lawyer for the insurance company, they certainly will be charging their client money. And if you end up taking a settlement less than what was initially offered, you will then have to pay the legal fees of the insurance company's lawyer, and those could be very, very high, and they may be more in fact than the amount of money you're going to end up collecting. So that's why you have to be very careful when you take these contingency fee lawyers at their word and they say, look, we're only going to charge you fees when we win the case. The other type of fees that lawyers charge are what's an hourly basis, where the lawyer will then keep dockets and records of the time and amount of money that you're going to be billed for. And in that basis, the lawyer will charge irrespective of whether he wins or loses, and you will be given a bill taking into account the time that you spent. That includes phone calls, text messages, emails, any communication that you have with the lawyer. So lawyers would ordinarily warn you not to just pick up the phone and start calling them, because depending upon their hourly rate, half an hour with a lawyer could be very, very expensive. Even 10 minutes can become very expensive. So when you have a lawyer that's working on your file on an hourly basis, you should try and avoid not making needless calls or emails and text messages, because all of those things could eventually turn around and be billed to you. Now, if you have a lawsuit and your lawyer is suing somebody on your behalf and he's charging by the hour, does it make sense to hire a lawyer who's charging $200 an hour, $300 an hour, or $400 or $500 or $600 an hour? Now, just because your lawyer is charging you $200 an hour in your civil case, it doesn't mean that the other lawyer, that is a lawyer who is defending the party, is charging the same. He could be charging his client $600, $700 an hour. And that can become a problem for you, because if you continue your lawsuit And imagine if your lawyer has a bill of $2,000 because he's charging at $200 an hour, and another lawyer is charging $600. You could have a bill on the other side of $6,000. So if you were to go to court on a lawsuit or a motion and you lose, your client, your lawyer's bill may be $2,000, but the opposing side's bill will be $6,000, and then you can end up having to pay those legal fees to your opposition. In other words, you may not just simply be paying for a lawyer who's charging $200 an hour, but you'll end up paying for that lawyer who's charging $600 an hour because that's the lawyer that the opposition got. Now, there's many cases where people have argued, look, why should I have to pay for an expensive lawyer because the opposition chose to get an expensive lawyer? Judges have ruled, look, a defendant in a case is not bound to pick a lawyer who charges $200, $300, $400. The defendants will pick a lawyer who they feel is best going to represent them and who's best going to look after their interests. And that lawyer could be charging $600, $800, $900, even $1,000 an hour. And if that's the case, you have to be very careful, because if you lose your motions, as I said, not only do you pay for your lawyer, you pay for the lawyer of the opposition on an hourly basis retainer. There are also cases where lawyers will hire, clients will hire lawyers, and they will be done on the basis of block fees. A lawyer will say, I will charge you a block fee, say $4,000 or $5,000 for a particular piece of work. And that can be done as well. But in that as well, the danger continues to exist that even though your lawyer is charging you a block fee for doing certain work, maybe it's $1,000 or $2,000, the other lawyer, the opposition lawyer, may have charged $5,000 or $10,000. So it's very important that you take steps having thought through about the cost consequences, because if you lose something, then as I said, you're not going to just pay your lawyer's fee, you're going to pay the other lawyer's fee. So it's not always the best option to find a lawyer who's charging you low hourly rates or charging you block fees, because those lawyers may not be as involved in the litigation. They may not be as experienced as the lawyers, obviously, who are charging at a higher rate. They have far more experience, they have trial experience, knowledge, and that is critical when it comes down to dealing with your litigation, especially if you're suing people. So make sure you get a lawyer who knows what they're doing. Ask about how they're going to bill you, ask about contingency fee basis, ask about hourly rates, ask about block fees, and then ask about how the lawyers are going to charge you with disbursements. Because you don't want to end up with a bill from a lawyer in which you're getting billed not only just the cost that your lawyer charged, but fees that you may have to pay to a defendant whose lawyer is far more experienced and charging at a far higher rate than your lawyer. And then that lawyer, being more experienced, can take advantage of loopholes and issues that your lawyer may not be familiar with. So make your choices carefully and pick your lawyers carefully. Starting a civil suit is not a simple thing. You have to consider all the consequences, and among those consequences are the cost consequences. And you may be suing somebody for damages, but the lawyer's fee may be far in excess of what those damages are going to be or whatever you're ever going to be able to collect.